Sir, you were charged with keeping a gambling place. You were facing up to a year in jail and a $4,000 fine.
Okay, pause. Did you catch that? The suspect is facing a year in jail and a $4,000 fine, and they're still running illegal gambling machines. Either they're incredibly confident, or they've watched too many crime documentaries. What would you do if you won $57 on a $1 bet in a sketchy game room? Let me know in the comments.
We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 19, 2024, Regulatory Enforcement Unit received a tip about illegal activity inside No Name Game Room in Harris County, Texas, namely gambling. Officers initiated an investigation on the same day and was assigned in an undercover capacity. The officer walked into the game room, was able to get a membership with help from a confidential informant, inserted $20 in an amusement redemption machine, then won $22 on a $1 bet, bringing his credit to $34.50. The machine allowed the officer to win more than 10 times the amount of his $1 bet, making it an altered video gambling device. On December 17, 2024, the officer entered in an undercover capacity, walked to an amusement redemption machine, inserted vice funds, and observed 3 violations. $30.50 win on a $1 bet, $29 win on a $1 bet, and $57.92 win on a $1 bet. The officer observed the defendant emptying out proceeds from the machines and servicing them. The defendant stated he could cash out the officer's winnings and asked the female to bring out the cash. On December 19, 2024, the officer executed a search warrant and found the defendant once again in care, custody, and control of the game room with a large amount of money in his pockets and device keys. The defendant admitted to being the manager of the game room.
All right. Mr. Manoja, I'm going to find that there's... Are you still working there? Is he no longer employed there? They shut it down? Okay. So don't engage in like-kind business, and then you'll be fine with us. Just don't run any type of establishment like this. That's the only conditions we're going to put on your bond. Do you understand? You have a lawyer. Sarah will take care of you. I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Sarah and she'll take care of you. I'll have you sign a reset with Ramona while you take a seat, get your bond condition. We'll sign it, and then you'll be free to go. Okay? Thanks, guys. Please. So if you can file.
No like behavior.
Right.
Yes, Judge.
No gambling.
Yes, Judge.
Mr. Thomas, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 21st, 2024, at approximately 1:30 a.m., the officers were dispatched in reference to a one-vehicle collision. Upon arrival, the officer observed the defendant's motor vehicle with major rear end damage and debris all over the vehicle from having collided into an apartment complex. Upon contact with the defendant, both officers and a witness observed the defendant with slurred speech.
Whoa, things just escalated. We've gone from a DWI to full-on assault. And here's the legal twist. When physical harm is inflicted on an officer during an arrest, you're now looking at a potential felony assault on a peace officer. That's not just a traffic case anymore. That's jail time with a capital J.
Strong odor of an alcoholic beverage and red, bloodshot eyes. The officer also observed the defendant to be disoriented and stumbling. While on scene, the defendant became physically combative, belligerent, and aggressive with the officers and attempted to kick the passenger door and headbutt the officer. During the altercation, the defendant grabbed the officer's right forearm and scratched him, breaking skin and causing him to bleed and feel pain. The officers made contact with the defendant's front passenger, his wife, who advised they were coming from a party where the defendant drank. And as the defendant was reversing his vehicle, he crashed into 2 garages and then fled the scene to continue looking for parking. The officers did not request standard field sobriety tests since the defendant was being combative and for officer safety. A blood warrant was signed and executed.
You look to see if he has any prior DWIs, please. Mr. Thomas. And then license.
Eligible, Your Honor.
Okay. Mr. Thomas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using illegal drugs or alcohol, I'll put you in jail. No more PR bonds for you. Do you understand?
Yes, sir.
If you don't have if you don't have liability insurance in your name, then you're also not allowed to drive, and that's a bond condition of yours as well. Do you understand?
Sir.
You have a lawyer. They will take care of you. It's your responsibility to stay in touch with them. If they tell me they can't get a hold of you, likewise, I will issue a warrant for your arrest. Don't become a danger to my son, to my city. Otherwise, I only have one place for you. Do you understand? All right. I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then you guys are free to go.
Thank you very much, Your Honor.
Please.
Yes, sir.
Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Please.
On May 14, 2024, the officer responded to a resident in Harris County, Texas, in reference to a terroristic threat. The officer made contact with the complainant, who stated the defendant, the wife's uncle, threatened to return to the residence with a shotgun to shoot him, and that he would shove the complainant's pistol up the complainant's ass, and that he would return with a cartel so they could take care of it. The complainant stated he believed the threats to be imminent and he feared for his life.
How did you get appointed so early?
He made a request for appointed counsel when he was in jail in Montgomery County.
Okay, so he was,
And y'all appointed me, and then he got transferred here and
got it.
received his bond conditions and general order bond last week.
All right, Mr. Rod, I'm going to find that there's probable cause to go forward with the case. I'm putting 2 conditions on your bond now. Not to be in possession of any weapons and not to have contact with the complaining witness in this case.
Yes, sir.
How long did you spend in jail, sir?
I was there the 14th all the way up till the time they transferred me here, and I believe I was released on the 20th.
How pleasant was your stay in custody?
It was not pleasant at all, Your Honor.
Then all I'm asking you to do are 2 things, and as long as you can do that, you and I will be best friends. Otherwise, it's not going to go well. I don't want to have to put you in, so just, that's all,
I
okay?
understand, Your Honor.
Got a great lawyer, Carl. He'll take care of you. Just make sure you stay in contact with him and all will go well.
Yes, sir.
If he tells me he can't get a hold of you because you're playing games, you're off the radar, I will issue a warrant for your arrest, okay? Just stay in contact, follow the conditions, and that's it,
Yes, sir.
okay? All right.
Thank you, Your Honor.
We need him to sign conditions here, and then after that, he's free to go,
Okay.
okay? All right.
Thank you.
He signed conditions already. I think they're pretty much the same as what you just said. And he also has a MOAB in addition to the bond conditions, which have no contact with the defendant, no weapons.
They were signed by the magistrate on the 20th, Judge.
I don't know how they put the MOAB on,
Got a copy of the MOAB.
and it's not a family member. There's no allegation of a family member, so they can't put the MOAB on.
It's still,
You know?
bond condition covered anyway.
But just so you guys know, I mean, there's no allegation of a family member in the information
Okay.
or in the 2B.
I believe it's
It's
the,
the wife's uncle.
right, the
Yeah.
complainant's wife's uncle.
Yeah.
But we can look at
It
the.
says, it only says, did then and there unlawfully threaten to commit an offense involving violence as opposed to like family violence or upon a family member. And so that's why just don't contact and you'll be fine. Okay.
Not a problem.
Nobody-
All right.
nobody calling for judgment.
I'm okay. I'm okay with it. Yeah, I see it. All
Thank you,
right.
Judge.
We got you.
All right.
Thanks.
Thank you.
Take care, sir.
You want to leave the warrant?
No, I mean, there's no,
You want to withdraw?
hey, what do you guys say? I mean, I don't know if we can technically have it, you know? Because normally you would have either terroristic threat of a family member or there has to be some allegation of,
And then file the MOAB.
I mean, that's a
Or we
different
can
thing. If you do that,
Weapon, just do
then
the
we
bond
can, you know?
Yeah.
I guess you guys think about what.
Are you okay if we just maybe step out and call the complainant really quickly and see if we can get in touch with them? And then we
Yeah.
can kind of decide.
Yeah, and the young,
Yes, sir.
This young, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On December 21st, 2024, the officers were dispatched to a disturbance call at 11:03 p.m. in regard to an intoxicated female who had become violent. Upon arrival, the officer made contact with the complainant, a supervisor for Acadian Ambulance, who stated that he observed the defendant throw a rock into the windshield of a Chevy pickup and then run off. The complainant advised that the defendant used to work for Acadian Ambulance and was no longer with the company. The complainant estimated the damages to be in the amount of $500. The officer observed the Chevy pickup truck with a broken windshield.
Got it. All right, Ms. Young, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using alcohol, I'm going to put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to have contact with the complaining witness in this case, not to be in possession of any weapons as well. So Francis, this one, I need you, since we're monitoring her for alcohol and drugs, please. Okay. What do you do for a living, man?
I did work in the city ambulance, like you
You're
said.
working now?
At an interview yesterday, they said I would be hired on. I guess it depends on also the background check.
My question is do you have income coming in?
I will be, hopefully.
Do you have the ability to hire a lawyer?
Yeah, I will.
Okay. If you have any issues, just come back and tell us. For now, we'll give you time. So I'll have you sign a reset with Ramona. You'll get with Francis for your bond conditions, and then after that, you'll be free to go. Don't use alcohol. Don't pick up a new case, because otherwise I'm going to end up putting you in. Do you understand? Okay, ma'am, please. Mr. Jefferson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, at approximately 3:30 a.m., the officers were dispatched to the 800 block on Louisiana Street in regard to a motor vehicle parked on the Metro light rail tracks. Upon arrival, the officer observed the defendant's vehicle on the tracks, with the defendant asleep behind the wheel of the vehicle.
On the tracks?
Yes, Judge.
Ugh.
The vehicle was turned on and in the parked position. Upon contact with the defendant, the officer observed slurred speech, glossy eyes, and an odor of an alcoholic beverage. Standard field sobriety tests were administered, 0 out of 4 on the one-leg stand, 0 out of 8 on the walk and turn. The defendant did not.
Yikes. This guy is already out on bond for aggravated robbery, and now he's asleep on the light rail tracks while intoxicated. The judge is clearly losing patience, and who can blame him? Viewers, should defendants with open felony cases get a second chance like this, or is it time for stricter consequences? Drop your thoughts below.
Finished the test, and HGN was 6 out of 6. The DIC was read and the defendant consented to breath. The results were .091 and .09.
He's on bond for an aggravated robbery.
Yes, Judge, that is correct. Out of the 174.
All right, can you tell me if he has any prior DWIs, please? And if he has a license?
And his license is eligible.
Mr. Jefferson, I'm now placing a restriction on you. I'm giving you a curfew of 9 p.m. to 6 a.m. And I'm going to put an ankle monitor on you so I know where you are at all times. You're on bond for a very serious case. Now you picked up a new case. It's very possible they revoke your bond on the felony case. Do you understand? I don't want you out in the middle of the night. If I find that you violate these conditions, I'm going to put you in custody. I'm going to protect my county at all cost. Do you understand? If I find that you're consuming alcohol or illegal drugs, likewise, your bond will be revoked. You will go into custody. And I'm telling you now, if I find that you're a public danger, I'm going to make it sky high. You missed court yesterday. So I don't want you to say anything. You have the right to remain silent. Exercise that right. The only thing I'm telling you now is I will give you a pass because you missed yesterday. If you ever miss court again, this is not going to happen. Do you understand? I'm going to reinstate the bond now. Francis, do you need the cause number for this case?
I have it.
You have it? Okay. No alcohol, no drugs, no weapons. And he now has a GPS monitor with a curfew of 9 p.m. to 6 a.m. You must charge this ankle monitor on a daily basis for at least an hour. If the battery goes dead, so does the bond. Do you understand?
Sure.
You can waive all the fees as well. All right. I'd like him to get it today as well. Francis, please. All right, Mr. Jefferson, what we're going to have you do is I'm going to have you go to Ramona, sign a reset, and then you're going to get with Francis for your bond conditions. You're already in enough hot water as it is. All you're doing is you're adding fuel to the fire, man. Really, don't say anything. I'm just telling you how to behave in this life. There's certain ways to act, certain ways not to. Do you understand? Come on. You were charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 19th, 2024, the officers conducted a traffic stop on the defendant's motor vehicle at approximately 10:20 p.m. at the 400 block of Little York Road after NCIC search on Texas buyer's tag returned it to gray 2020 Ram pickup truck, even though the defendant was driving 2006 Mercury Montego. Upon contact with the defendant stated the motor vehicle belonged to him and his sister. The defendant advised he paid a guy $65 for the tag. Upon further inspecting the vehicle, the officers found the fictitious tag had the defendant's vehicle information on it, but the plate number came back to another motor vehicle. Inventory of the vehicle revealed another fictitious tag in the center console, and the defendant was also in possession of two fictitious documents affixed to the rear of the vehicle. The defendant made a comment that he knew one of the tags was fictitious.
Okay. Mr. Dominguez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive unless you have a valid Texas driver license and liability insurance. If I find that you do and
Doesn't have a driver's license.
you do not have a Texas driver license, you are not allowed to drive. You will be signing a promise with me today that you're not going to drive. Mr. Dominguez, if I find that you do, I'm going to revoke your bond. I'm going to put you in jail. If you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with. And then they're going to ship you off to immigration. This is the only warning that you will get from us. So take it as you will. Do you understand? You need a lawyer to represent you in this case, and we're going to give you time to go find one. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Ramona, sign a reset. After that, we will get you time to go hire a lawyer, sir. Please. Mr. Perdomo Ramirez, you were charged with reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On December 21st, 2024, at approximately 5 p.m., the officer conducted a traffic stop on the defendant's vehicle after observing it travel over 90 miles per hour in a 65 mile per hour zone. The vehicle continuously cut across multiple lanes of traffic to maintain high speed and swerved in front of others, causing them to brake. The officer also observed the defendant's vehicle follow other vehicles too closely in an attempt to pass them. The officer followed behind for approximately 4 miles before initiating traffic stop. The defendant admitted to not having a license.
Mr. Perdomo Ramirez, I'm going to find that there's probable cause to go forward with the case. You do not have a Texas driver license. You are not allowed to drive. I'm making that a condition of your bond. If I find that you do, I'm going to revoke your bond, put you in jail, and if you're unlucky enough and you're not in this country with permission, they will put an immigration detainer on you, and you will wait until this case is over with in jail, and then they're going to ship you off to immigration. Do you understand?
You're going too fast. I didn't understand.
You are not in this, if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will sit in custody for about 3 to 4 months waiting for this case to be over with. And then you're going to wait another couple months for immigration to take you, where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do to you. Do you understand? I want you to understand what would happen to you if you go to jail. I'm ordering and I'm placing conditions on your bond now. If you violate these conditions, I'm going to put you in jail. This is the only warning that you're going to get from me. Do you understand? I'm warning you not to drive. I don't care what is going on in your life. If you do not have a Texas driver license and liability insurance, you may not drive.
Okay.
Do you understand?
Yeah.
You will be signing an affidavit. This is a promise to me you're going to make that you're not going to drive. I hope that you heed this warning and take it seriously. There will be no more. We will have you sign this affidavit promising us you're not going to drive. I will get you to Ramona where we will have you sign a reset and we will get you out of here. When you come back, you need a lawyer to represent you, sir. We're going to give you time for you to do that. Please. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 21st, 2024, the officer responded to a major crash at Interstate Highway 45 in Harris County, Texas. The officer observed 3 wrecked vehicles, including the defendant's vehicle. The officer discovered the defendant's vehicle was driving at a high rate of speed and struck the rear of another vehicle, which was pushed across another lane and subsequently struck another vehicle. The officer made contact with the defendant, the driver, and the officer observed staggering, the defendant trying to sit on the ground due to poor balance, a strong odor of an alcoholic beverage, slurred speech, and bloodshot glossy eyes. The wheel witness, the passenger of the defendant's vehicle, observed the defendant drink 3 40-ounce Smirnoffs and stated the defendant insisted that he drive as the big brother. The wheel witness stated the defendant did not stop at a red light at an intersection, hitting another vehicle. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant read the DIC and consented to breath. Those results of the breath test were 0.058 and 0.054. A DRE and blood sample were requested, to which the defendant consented. The DRE determined the defendant showed signs of being the influence of a narcotic, analgesic, and dissociative anesthetic.
Got it. Mr. Machado, I'm going to find that there's probable cause to go forward with your case. Have you prior to the DWI's license?
No DWIs, Your Honor, and eligible license.
Mr. Machado, I'm ordering you as a condition of your bond not to drive any vehicle that doesn't have insurance with your name on it. Do you understand? If you're caught driving a vehicle and you don't have insurance on it, I'm going to put you in jail. No more PR bonds. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, into jail you will go. No more PR bonds. If you don't have anyone to pony up $5,000 to $10,000 to get you out of custody, you'll be sitting in there until this case is over with. Do you understand?
Yes, sir.
How old are you, sir?
26.
What do you do for a living? Sorry?
Paint helper,
Okay. What kind of money you make?
now 15 and on.
Okay. And who do you live with? All right. We're going to give you time to hire a lawyer because you need a lawyer to represent you. Don't wait. There's a lot of timing requirements with the DWI, so don't sit and wait a month, 2 months because you're only hurting yourself. You understand? All right. I'm going to get you to Ramona's. We're going to have you sign a reset. Then you'll get with Francis for your bond conditions, and after that, you'll be free to go. Don't pick up a new case and don't use.
Yes, sir.
All right. Mr. Racinos, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, the officer was dispatched to Fondren Road to meet the firefighter call. Upon arrival, the officer was advised by a Houston Fire Department medic that the defendant, who was the driver and sole occupant of the vehicle, was asleep behind the wheel of the vehicle while the vehicle was on and in drive and in the middle of the intersection. Upon contact with the defendant, the officer observed slurred speech, a strong odor of an alcoholic beverage, and swayed balance. The defendant denied drinking. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused. Blood search warrant was signed and executed. During the reading of the DIC, the defendant wet his pants for a second time.
Mr. Racinos, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol illegal drugs or unprescribed controlled medication, you're going to be randomly tested. If I find that you're consuming alcohol or illegal drugs, you will go to jail.
Eligible license and no priors.
Got it. If you don't have liability insurance in your name, you're not allowed to drive any vehicle. Do you understand? And that is also a condition of your bond. We're going to give you time to hire a lawyer, so I'll have you sign a receipt with Ramona. After that, you'll get with Francis for your bond conditions, and then you'll be free to go. Don't pick up any new cases. Do you understand? Okay, come on. Mr. Tsakital, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On December 21st, 2024, officers were dispatched to a firefighter call for a person down at approximately 1:24 a.m. Houston firefighter advised the officer that he observed the defendant to be asleep behind the wheel of his vehicle, despite attempts to wake the defendant with their horn. When the officer arrived on scene, he observed the defendant inside his vehicle while the vehicle was on and in park at the 4300 block of Bylock Road, and the defendant admitted to drinking about 8 drinks and stated he had just left the sports bar. The officer observed the defendant to have glassy eyes, poor balance, and odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. While inventory of the vehicle, the officer located one open 12-ounce Coors Light can in the center cup holder, which was 1/4 full and cold.
Drinking while driving?
Yes, Judge. And the DIC was red, and the defendant consented to breath. The results were .087 and .08.
Mr. Tsakital, I'm going to find that there's probable cause to go forward with your case. I'm now taking away your privilege to drive. You are not allowed to drive whatever for any reason. Do you understand?
Yes, sir.
You will be signing an affidavit with me today, promising me you're not going to drive, and I don't care what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care what your reason is. There's no justification you can give for getting in a car and driving. Do you understand?
Yes, sir.
This is a court order. This is an affidavit and promise you're making to me now that you're not going to drive. Heed this warning. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. We are going to reset your case to give you time to hire a lawyer, so I'll have you swear to this. We'll get you to Ramona with your reset, and then Francis for your bond conditions. Okay, who do we have here?
This is Christopher Gomez on page 9, Your Honor.
All right, good morning, Mr. Gomez.
Good morning, Judge.
All right. So with us, you were on bond for a felony less than a gram case from October. In December, you pick up a weed case, and now you've picked up another weed case. You are now charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, the officer observed the defendant's vehicle, a silver BMW, bearing the wrong license plate. The officer conducted a search and learned the license plate was registered to a Hyundai 4-door with the expired registration of December 2022. The traffic stop was conducted, and the officer observed the driver throw a brown object out of the driver's side window and land on the road. The officer made contact with the defendant, the driver, and sole occupant, and observed a strong odor of marijuana and a green leafy substance residue on the front of the defendant's shirt, known to be marijuana based on training and experience. The defendant stated he removed plates from his mother's motor vehicle due to not properly registering his motor vehicle. The officer walked back to where the defendant threw the brown bag and located a large cigar containing marijuana. The weight of the marijuana was 2.5 grams.
I'm going to find that there's probable cause to go forward with your case, Mr. Gomez. My question to you what condition did we place on you before? We put a no driving affidavit on your prior case. I'm now revoking the bond on that case, and I'm going to raise it up. I'm now finding this bond wholly insufficient, as well as you refuse to comply with bond conditions set with this court, and I'm finding that by clear and convincing evidence. As a result, I'm finding this bond wholly insufficient as well. We are now taking you into custody because of a felony warrant, but I'm now revoking the bond on your first case as well. Goes with you.